Good morning, everyone. My name is Garrett Sheehan, President and CEO of the Greater New Haven Chamber of Commerce. We're going to get started in just a moment with our webinar. We have a great panel today to talk about legal liability as the reopening gets underway today. So we'll get started in just a moment. If you're just joining us, we'll get started in just a moment. We're going to let a few more people join in. All right. Good morning, everyone. Again, my name is Garrett Sheehan, and thank you for joining us for our webinar this morning, put on behalf of the Greater New Haven Chamber of Commerce and Quinnipiac Chamber of Commerce, as well as the other chambers that are our streaming partners. We thank them. Also want to thank all of our investors who help support the chamber, especially in times like this, our premier investors, also our key investors that make a significant difference for us to be able to put on programming like this, especially as we go through this very difficult time. And then also all of our principal investors as well. We really could not do this type of programming for as long as we've been doing it without all of their support. We do have a great panel this morning. I know as we hit reopening here on this May 20th, there are still a lot of questions remaining as to what that means for actually operating your business. I'm actually here back at the chamber for the first time in a couple of weeks, and we're opening the doors today as well. It's not going to be a huge rush or a capacity issue, but it is good to have business back up and running. One of those issues that many people are dealing with is legal liability. And so we brought together a panel this morning of two fine attorneys in our region. I want to introduce Caroline Park with Wigan & Dana, and Sal Gangemi, a partner with Murtha Kalina. And they're both joining us this morning to try to field some questions on legal liability. This field is wide open. There are no straight answers. It's trying to figure things out as we get into this new process. So we put a disclaimer out at the beginning that we're not going to have exact answers, and a lot of it is still up for interpretation by courts. And the process that will go forward and what the states and the federal government will do. But with that, I'm going to introduce Sal and let him speak for a couple minutes about any issues he's seeing, and then Caroline, and then we'll open it up to questions. So you can start putting your questions into the chat. That's probably easiest. If they end up in the Q&A, I'll find those as well. So Sal, good morning, and thanks for joining us.
Good morning, and thank you for having me. Today's a big day, because today it appears that all 50 states to some extent are reopening, and so is Connecticut. And in terms of the issues that we've seen, one of the, I think one of the biggest issues that I've been dealing with is employers who have sought to reopen, or at least reopen on a limited basis, and recall some workers who are concerned, let's say, about coming back to work because technically there's still a pandemic, and feel content or would prefer to remain on unemployment rather than working. So I think that that's one of the major difficulties that some of my clients, some of them are having, is trying to get people to come back. And one of the issues, I think, is to what extent does unemployment or the provision of unemployment insurance, including the federal $600 a week unemployment insurance supplement, to what extent has it disincentivized people who are otherwise able to work to return to work, and either working for an essential business or now otherwise? I think the next couple of weeks are going to be tricky, because I don't think people are going to be, despite being open, I don't think that we're going to have, I think we're going to have a lot of people just not coming in, essentially.
It's a good point. There's a lot to do as far as just consumer confidence to getting to the point of having access to people in restaurants and stores.
Right.
Caroline, good morning, and thanks for joining us.
Thanks,
What are some of
Garrett.
the things you're seeing?
I'm also fielding a lot of questions from clients along the lines of what Sal talked about in terms of reluctance of employees to return to work. I've been working with a lot of employers who were open in some capacity during the last few months, either with employees teleworking or working remotely, or to the extent they're essential, working at the facility. And we've been working through lots of issues related to employees' fears and concerns about returning, employees who are high risk either because of their age or because of pre-existing conditions, and how to handle those employees, some of whom really want to return to work, notwithstanding the governor's guidance, and some of whom who do not. Absolutely, I think, as Sal mentioned, the role of the federal unemployment booster of $600 a week has changed this dynamic a lot, because, for the first time, unemployment could provide 100% wage replacement, where under the normal Connecticut formula, it typically does not. So we're seeing some employee behavior incentivized that was not before, and I think that's creating a lot of problems for employers, particularly now that they may need to reopen with their full complement of employees.
No, that's a good point. And we should probably say at the start too that the governor's order does not require that people in these age groups cannot.
That's right. Yeah.
I think there's some question about that. I guess for both of you, what are some of the things that you're telling employers as they start to face these questions with, let's say an employee who's over 60 years old, may be concerned about coming to work? Because there is no official guidance out right now as to what they're supposed to do.
So first of all, obviously we can't bar anyone from coming to work who wants to come to work unless they are in fact sick or experiencing symptoms, COVID-19 related symptoms. And we can't, unfortunately, employers can't take it upon themselves. I say unfortunately, but fortunately, employers can't take it upon themselves to sort of dictate to an employee who's either pregnant or over the age of 65 that they shouldn't be coming back to work. Because the bottom line is, if they want to come back to work, they should be entitled to come back. Now, having said all of that, anyone who is in a high risk category at this point needs to be accommodated as far as addressing their concerns about coming back to work. OSHA requires us to have, or requires employers to have, a safe workplace. All right, and OSHA, OSHA refers to this concept of an employee. In order for there to be an OSHA issue, let's say, the employee has to reasonably believe that they are in danger, in imminent danger. Mm-hmm. A generalized fear of contracting COVID-19 is not enough. But it could be reasonable for someone over 65, someone who's pregnant, someone who manifests other comorbidities from being concerned about returning to work. So I think the safe thing to do right now is just accommodate people. Okay, it's certainly not going to be an issue, but I think it's important to accommodate people's concerns, at least while we're trying to until we get additional guidance or more guidance from the authorities.
Yeah, I agree with that. And then just to add on, so in normal circumstances, if you have a job to return to, you're not eligible for unemployment. The Connecticut Department of Labor's guidance that's available right now says, if you have a job but you have sufficient cause for not returning, you may be eligible, and the DOL is going to do case-by-case determinations on that basis. So I would expect that we would see at some point either further clarification or get some sense of how these eligibility determinations are panning out for employees who have refused offers to return to work because they are high risk, and possibly seeing that the Connecticut Department of Labor is deeming them eligible for unemployment because their risk factors constitute sufficient cause for them to refuse the offer. So in terms of what would bridge those employees through an accommodation that might potentially be an unpaid leave of absence, I think we will see clarification about unemployment eligibility for those employees during that time.
Caroline, it is kind of, and I don't expect you to have the answer to this, but it's kind of vague from what Department of Labor is saying, because I've heard the deputy commissioner say, oh, definitely, if you have an employee who just does not want to return to work, file the claim, we'll pursue that. At the same time, you see, the difficulties they're just having with the overall flow of claims. So, there's some question just about pure logistics, how they could do that. But then also the language that you just referenced that does leave open a wide area of where, even if there is a dispute, it may end up in favor of the employee.
Yeah, I think it may. I mean, like you said, this is all logistically, this has been difficult. The Connecticut Department of Labor has been so overwhelmed with just standard claims, let alone eligibility determinations where they have to make case-by-case assessments. So, I mean, at least through my clients, I haven't really seen anything, formal come out where we were, challenging eligibility or not certain if someone would qualify. Haven't seen anything like that just yet. I think they're still working through that enormous backlog, and also working to process the claims of the independent contractors, 1099, all the self-employed people who are now eligible that they need to process for the first time. So you're right, there's so much uncertainty. I have no idea when we'll see where the chips fall.
When the money runs out.
When the money runs out, yeah, then we'll know. Then we'll know who was eligible and who wasn't.
Very true. Very true. I think we should mention too, there are a couple of options for employers, because I ran into this in talking to some salon owners last week who were concerned about reopening. As an employer, you do not have to bring back everyone all at once. So if there's employees that you want to wait, just the fact that you're opening does not mean that everyone has to come off unemployment. It's when you offer them that job. And then also with the Paycheck Protection Program, if you are part of that stimulus program, I know it feels awkward for an employer, but it is okay for you to pay someone while they're at home. And that was part of that program, was to kind of pause for a moment in time. And, for you to be eligible for that grant, if you have to pay someone while they're at home, while that can seem strange, that's not against the rules. Mm-hmm. I guess, are you guys seeing similar questions that people are having?
Yeah. Yeah, and on the PPP part of it, luckily there's been a little more clarification with the terms of the forgiveness application out now. Employees who are terminated for cause or employees who refuse your offer to return to work, they're not going to count towards your head count for forgiveness purposes. So that's a really important clarification for employers who are trying to wrap their heads around what their PPP forgiveness formulas will look like. There's no definition of cause if you've terminated someone for cause, but I would think about it as you would in a normal setting where you're trying to manage risk and liability, just making sure your ducks are in a row when you're proceeding with a termination, especially a sensitive one, and try to be limiting those to significant attendance issues, misconduct, dramatic performance concerns, things like that, until and unless there's something more clear about what cause means to the Small Business Administration.
Right, and I wanted to add something about the PPP that something that I've encountered, and Caroline, maybe you have too. Mm-hmm. So one of the I see that there's a bit of an inconsistency as far as the loan forgiveness issues when you have an employee who doesn't want to come back to work, and they've been offered the same, I guess, the same terms and conditions of employment that existed prior to, prior to I guess prior to being terminated, laid off or furloughed. What's interesting, so clients are asking me, we could bring them back. We want to bring them back because we need to bring them back prior to June 30th. Okay, in order to enjoy the benefits of this loan forgiveness program, but we can't pay them what we were paying them before, and so we'd like to, reduce or at least propose a lower pay because they've seen some guidance out there that indicates that if you agree to pay them 75% of what their compensation and benefits was before, that suffices. But then you have this other language that says that an offer can be rejected, an offer to return to work can be rejected if they're not paid the same, which to me means 100% what they were paying before. So I see this so right now what I'm doing is I'm advising people just bring them back at what they were getting paid prior, even though there's some rules out there and some guidance out there that says you can reduce it up to 20% or 25%. It's probably not a good idea because if they reject the offer, it looks like you might have a problem with loan forgiveness. Is this something that you've come across too?
A little bit, and I'm seeing the same inconsistency. I think from a practical perspective for employers too, as they figure this out, if you reduce people, you're going to have a hard time spending your full PPP loan on qualifying costs, on meeting that 75% of payroll. So it's going to be more difficult. If that's your goal, to kind of maximize your total forgiveness pool, you're going to have a harder time spending your loan on qualifying expenses if you've reduced payroll. So I'm seeing the same conflict that Sal identified, and I think that kind of practical consideration for most of my clients is what's kind of prevailing and saying, maybe reductions don't make sense for us right now.
Right. And there's definitely a next phase of all this in that, now we're just getting back to work, but what is the economy after this? And so, and also with the incentive programs, and I know Congress is, potentially working on another phase, and so maybe there'll be something similar to PPP out there. Maybe it'll have different requirements because definitely there's an economic slowdown that's occurred too. So it's as we've been talking, it's not going to be 100% straight back to full speed on work.
Sure.
Starting to get some questions about PPE. So personal protective equipment. I know we're starting to throw around a lot of 3-letter acronyms here, but the state did put out guidelines for the different work groups that are allowed to be open. And full disclosure, I was on the governor's advisory committee and did see those, and we had some input on those. How should employers handle those, especially in dealing with their employees? Should they see that as set in stone that they must follow these, and also does that provide them some protection by doing so?
I think it's very important. So this is a very strange time because we're seeing things that are unprecedented. That, by the way, that's another word I'm tired of hearing. That and the new normal. I want to make a pact to not say to say that, but I can't help myself. I just keep saying it.
Sal, I'll commit to that pact.
Yeah, same with in these challenging times, in these difficult times.
And I'm run with the flag, but so the this concept of employer liability for people getting sick in the workplace is an issue that concerns me, because I think the assumption has always been, or at least it's always been my assumption, maybe I'm wrong, is that injuries or illnesses that occur during the course of employment are things that are covered by workers' compensation law, right? So that if I go to work and I get sick at work, how am I going to sue my employer, okay, for my getting sick? This is a workers' comp issue. At least that's my view. But with all this discussion about bills and proposed laws limiting employer liability, who knows? Maybe I'm wrong. maybe this changes the landscape. Having said all of that, I think it is absolutely critical that employers follow the at least, right now, the phase 1 guidelines.
Yeah, I agree with that. Yeah.
Okay. And there's no reason not to. There's no reason not to. I think implementation is certainly going to be tough, especially, offices and workplaces are going to need to be organized in such a way to maximize the protections that need to be in place. And I realize it's a pain, but I think at this point, there's no other option.
Yeah, and I think for businesses liability, both for employers and customers, we don't know yet how this will shake out, as Garrett said at the beginning, but a huge issue that litigants will have will be causation of proving where you contracted the virus. I mean, you could have an employee at work all day in a space where you've taken precautions, every recommended precaution. They could be negative. They could contract it at the grocery store that evening in a 15-minute visit. So it's going to be really difficult to figure out, both in the workers' comp area and then just in terms of regular torts, as they might apply either to employees who are excluded from workers' comp or for customers or your clients, is proving that causation element, that your conduct or your misconduct or your lack of preventative measures were what caused their harm. So I think, just without knowing exactly what this will look like, a great defense is a good offense, which means follow everything. Have a good faith preventative program in place so that if you're facing a claim like this, you can say, what else could we have done? We followed all the available state guidelines. We were in compliance with what the CDC and OSHA recommends, and basically be in a place where no one could find fault with the measures that you took. And that's going to be the sort of good faith argument that will, I think, as this all pans out, protect employers and businesses from potential liability. Again, all subject to, I don't have a crystal ball, but that's what I think will end up being very significant for business liability.
Better safe than sorry, right?
For sure, yeah. For sure. And I mean, from a business perspective, what a great way to build customer confidence and employee confidence as we, roll back to our old normal. Can I still say old normal if I can't say new normal?
Don't say normal. As
we roll back to the old normal in the coming weeks. So, will there be opportunistic plaintiffs lawyers? I can say that as an employer, as a lawyer that represents businesses. Will there be those lawyers that are looking to establish a cottage industry around negligent exposure to COVID-19? I'm sure of it. I'm sure we will see claims like that. I saw one was filed in Utah already about employee exposure. To give you a flavor of that case, the allegations, which the company has already denied, are that they operated in violation of state and federal guidelines regarding their industry, that they didn't supply employees with the PPP that they were supposed to, that they did not, what else? Oh, they ignored employee safety concerns. So that should give you a flavor of the types of allegations and the types of businesses that might be particularly vulnerable to claims like that.
And in the regulations, one of my goals with it, and I think for the most part it is that they don't get so specific. They're broad, because everyone's business location is going to be different. The physical space just itself and what people can do. So, what I've been advising is just be common sense with that. You want to keep distancing, and you want to have people wear masks. Now, the masks is one thing that keeps coming up. I know store owners are concerned about having to tell a customer that comes in that they have to wear a mask, but that also applies to employees. And the state seems to be pretty stern on that, in that you can, or they are requiring everyone to wear masks with a health exception as the only out clause there. Anything about as far as the just employee-employer relationship and requiring people to wear masks?
I certainly don't see any issue, except for the fact that there may be some employees might be able to claim that there are some allergic reactions to the type of material that's used for the mask. But I think now, maybe a month ago this would have been a problem, but I think now that's something that we could accommodate. I think that's something.
Yeah, I've also seen with a couple clients encountering employees that have asthma or some other condition that makes breathing a little more difficult, and they find the close fitting either surgical or cloth masks to make it more difficult for them to breathe. And those employees have been successfully accommodated so far with a plastic face
Right.
shield, which is a pretty inexpensive fix that's resolved, has the employee's nose and mouth protected, but is not kind of presenting that breathing difficulty related to whatever medical condition they have. So I'd be creative. I think there can be pretty easy fixes if you're running into obstacles like that with your employees.
I know this is not really your guys' area, but any advice you'd give with dealing with a customer or a visitor to a business that walks in?
Look, I think the only customers you're probably going to have an issue with are people that don't know what's going on. So certainly, I agree with you. People are always trying. There are these people who are trying to make a point of issues, but just like you're willing to keep out people who look like they could cause a disturbance. I think you certainly need to enforce. I certainly think you need to enforce the guidelines with respect to customers coming in. Certainly can't please everyone, but at the end of the day, it's the right thing. It's the smart thing to do.
Yeah, I agree with that, Sal. And maybe depends on your business. Maybe it doesn't have to be black or white. If they don't come in, maybe you can still offer curbside service to them. Are you a store? Can you run something out to them? Is there a way to keep their business while also protecting those in your store?
Right.
Question here, can you bar employees from coming to work if they had contact with a diagnosed or suspected COVID-19 infected family member or other person?
So let me just make a comment here, because here are questions that this is similar to questions that I've gotten. You should not ask, in terms of asking an employee about contact with someone who has a COVID-19 related condition. The question should not be so specific. And for example, you shouldn't ask these people, does anyone in your family have COVID-19 or have anyone in your family exhibited symptoms of COVID-19? That's a bit of an impermissible inquiry, okay, in that sense. The better question and the permissible question is, have you come in contact with anyone that's been subjected to, that's been exposed to COVID-19 or rather is exhibiting COVID-19 symptoms? And yes, you can. In fact, you're required to make sure that these people do not come to work if in fact they've been exposed to someone close to them who's exhibited symptoms.
And then just to follow up on what Sal said, the next question may be, so what happens to them during that period of time that you keep them out of work? Depending on the circumstances, if they're actually caring for a family member who has COVID, they might be eligible for leave under the FFCRA. It's also in the CTDOL unemployment guidelines that if you're not sick and your employer is requiring for you to stay out on a quarantine period because of exposure, then you might be eligible for unemployment during that time if you don't have other paid leave available to you.
Similar question, and it just came up as well, is the temperature testing. And I know we have many employers who have been implementing this already, especially in manufacturing settings over the last several weeks. But any issues or concerns for the employer who's just starting, who's going to be conducting this? Are they allowed to require that they take every employee's temperature? Any privacy concerns between the person who's taking the temperature?
Yeah, so luckily in all this chaos, this is one where the EEOC has been pretty definitive. So we don't need to get much about this. You can require a temperature screen. The important part to note is that it qualifies as a medical exam under the agency. So whatever records you end up having around this temperature program, if you're making notations, employee's temperature, those need to be maintained in a confidential way, just as you would any other employee medical record, segregated from their personnel file. But the EEOC's question and answer document has a specific, can an employer have a temperature screen? Yes, but it's a medical examination. So There's not too much gray area on that one. I think the one gray area is not legal exposure, it's just how effective it is, because some people don't, their symptoms do not manifest with a fever. Some people may transmit the virus long before or after they have the fever. So, while there's certainly lots of good reasons to do it, you can't count on it being the 100% effective thing that will keep the virus out of your workplace. It has to be one element of a bunch of other strategies that you're using to keep your workplace safe.
Right. And practically speaking, and Caroline mentioned this in terms of segregating the documents or keeping documentation concerning these results private, is that, when you're taking the temperatures, or if you're deciding that you're going to take temperatures, try to maximize privacy there as well, because what'll happen is, or what could potentially happen is, someone will see a coworker coming into work and then won't see them again. Okay, if in fact, subsequent to getting their temperature taken, because if their temperature is sufficiently high, they're going to be sent home. So people will start to figure this all, people will figure it out. So to the extent that you can, try to maximize privacy in taking those tests, those temperatures.
Along the same lines, if someone did test positive and either you found out that day while they were at work, or it happened the day before, how does the employer deal with that? Do they let all the other employees know? And I assume you keep it anonymous, say an employee tested positive. How would you recommend people deal with that?
Well, look, everyone, practically speaking, and in a lot of workplaces, I think people figure these out on their own. Having said that, what you shouldn't identify the person who's tested or who's exhibiting these symptoms. What you should do is speak to the person to find out. And this is the kind of advice I feel like I've been giving this. This is like old school advice. I've been giving it for 2 months, right? So ask them who they've come in contact with, so that you can inform these people that they might have come in contact with someone who's exhibiting these symptoms, but not to name the person. Practically speaking, they're going to figure it out, but they shouldn't figure it out from you. They shouldn't find out from you.
Yep, I agree with that.
And I got a question too, and this is more on the medical side, but a question about if you have to close the office. I've heard from medical experts, it's just finding out what the person was for the previous 48 hours when they were last in the office, maybe doing a cleaning. But from a legal standpoint, no requirements have been put out there. And I'm asking, you haven't seen any requirements about you have to shut down or anything like that if you had a COVID positive case?
No, I have not.
I have not, nope.
How about a situation is hypothetical, but if an employee is back at work and they feel like something is not safe at the workplace, they make a claim like we don't have enough personal protective equipment, or there's not enough hand sanitizer, or not enough space. What should be, if the employee comes to the employer first, what should that process look like for dealing with a situation like that?
So that's a great question, because I think this is an area actually where an employer's liability could be pretty straightforward, and that would be potential retaliation against an employee who's expressed a good faith concern about safety and security. So I think, first of all, be aware of the potential for retaliation concerns around that employee, but 2, listen to what their concern is and take it seriously, and then be very transparent in terms of communicating with them about what steps you've taken to address that concern. So if it's that they think, that some certain step is, not being taken that should be, and it turns out you figured out a different way to address that same safety concern, I think communication and transparency with employees around those steps that you're taking will be enormously useful in those cases. But definitely be aware of the potential for retaliation claims being filed by employees who say, I lodged this good faith concern about the conditions at my workplace and I was fired in response, or, some other retaliatory action was taken against me.
That's why you need to err on the side of caution with all of this, and be as conservative as possible, because the retaliation claims are and I agree with you, Caroline. I mean, listen, the underlying reason may not have had anything to do with it,
Right.
just like in any other case. But as long as there's a good faith
Yeah.
claim made, you open the door to a retaliation claim, and those are tough. Those are tough.
Those are really tough. Yeah.
Any documentation, we talked about things, medical records and that, but anything as far as cleanliness and what you're doing from a cleaning standpoint that you need to document?
You mean for workplace? I would certainly, you certainly do need to implement or should implement a cleaning protocol. And I would say that under those circumstances, although you may not be required to document it, I think it's a good idea that you do so. I'm not aware of any specific rules saying that you have to document it, but I think it's a good idea. I think it's certainly a wise idea to do it.
I agree. Yeah, especially if, and you might consider this, if you know you have a positive case of an employee, you might retain a third party to come in and do a professional clean or something like that. Certainly if you're taking measures like that in response to a positive case, as opposed to just the ongoing cleanliness and maintenance, definitely retain records of those as part of documenting your response to a positive case in your work environment.
Anything around, just a question from someone about if had an infected employee, do we need to keep everyone out of the workplace for 2 weeks? And we're not going to get into the health side of that, but if someone does have a positive test, let's say it was someone who was working right next to another employee, would you recommend, and again, I'm not asking on the health side, but let's say they decide they want to do a 2-week stay home. That's just a situation where the employee pays their salary and asks them to stay away from the workplace. That would be a, I guess, acceptable way of handling something like that.
I don't think it's unacceptable. I think in terms of having them stay home for 2 weeks, I think that's probably a good idea. I don't think you need to shut down the entire workplace. Just people working closely with that particular person, have them stay home for 2 weeks and continue to pay them, or the FFCRA provides that an employee can be paid while seeking a medical diagnosis. It's up in the air what that means. Yeah. Some people say it applies to just the time spent in going to get a medical diagnosis, which really doesn't make much sense. But I would certainly say to err on the side of caution there and have the employee not report to work or have 14 days.
Yeah, and then I just suggest whatever you decide is going to be your response, so just be consistent. So right. You don't want to, be making case-by-case calls. The coworkers next to this employee have to be kept out, but not next to that employee. Right. My dog has a lot of thoughts about this that she's chiming on.
Hey, she's going to start, mine's going to start barking. She's like walking around here. Oh, there she is. I thought she was going to bark at one point when she heard yours go. Would have been fun.
It's better. My kids are fighting right now, so as long as you can't hear that. So, on waivers, did see someone ask about if they should have either their employees and customers fill out a waiver when they first enter the premises. Any thoughts on that?
I don't know how enforceable those would be anyway, so I wouldn't recommend it. I think from a business standpoint, it looks terrible for customers. To have to sign off on a waiver. Come into my store, you might contract something, and I don't think that's a good idea.
Yeah, I agree. There's a whole body of Connecticut case law about the non-enforceability of waivers of your own gross negligence, potentially negligence. So, no matter what you sign, if they could prove that they still were harmed because you were negligent, the waiver is not going to mean anything. And, along the way, you might have damaged a customer-employee relationship.
And you guys are not in the insurance industry, but someone asked if it would make sense to get insurance to cover for potential lawsuits from COVID liability.
I mean, I'm certainly not an insurance person, and I could be wrong about this. I don't even know if something like that exists.
Yeah.
And even if it does exist to some limited extent, I don't know that it would cover necessarily, what the person who asked the question is concerned about. I don't know,
Right.
Caroline, are you aware of any of that?
No, I mean, I guess the one thing you could do kind of as a preventative measure is reach out to your provider, your
Yeah.
insurance provider, your broker, and figure out the terms of your EPLI if you have it. There's all sorts of carve-outs on employment practices liability insurance. It might be worth your peace of mind now to get a handle on what type of employment-related COVID claims might be included or exempted from your EPLI coverage. I don't know. I'm sure the insurance industry is going to brew up a whole bunch of products they can sell you for the next pandemic. But for right now, I don't know that, I don't know exactly what, I don't think there will be much coverage.
Well, we're going to get close to wrapping up. So if anyone has any last questions, please feel free to put them
Garrett,
in the chat.
I think your kids have a question.
Yeah. I fixed like 3 toys in the last 5 minutes. So. But if anyone has any other additional questions, put them in the chat. I do just want to remind everyone, obviously with the reopening, we're trying to promote all the businesses that are open today. So you can go on social media and use our hashtag GNHCC reopen together and put that either on Facebook or LinkedIn. And we're promoting all the businesses in our region that are open today. Sal, Caroline, leave it to you for maybe a couple closing thoughts from each of you.
So one of the things that we didn't talk about, and I just want to make mention of it, is when you're permitted to ask employees before coming to work to get confirmation that they're not sick after having been sick with COVID-19. Just keep in mind that it may not necessarily be the easiest thing in the world right now to get a doctor's note. It's probably gotten a little bit better. And while you can request one, I think you need to be flexible in that respect.
Yeah, I'd agree with that. I think that applies too if you're dealing with somebody kind of in the if you're in the ADA accommodation process with somebody and you've requested medical documentation, be flexible. Maybe not so much about the sufficiency of the documentation, but maybe the timeline, understanding that,
Right.
It may take somebody a few more days to get a note to support an accommodation request than it would in normal times.
And we'll squeeze one last question in here. Someone asked if they should be proactive and talk to all their employees about their individual situations, concerns, maybe any health risks, or should you wait for the employees to come to you about issues they may have with coming back to work?
I don't think they should be asking anyone if they have any health concerns that could cause an issue. I think if the employer is certainly aware of something, they might need to take some proactive steps, but otherwise wait for the employee to approach you.
Yeah, I agree, Sal. You might find out a whole lot of information about your employees you really don't want to know in that process. With that said, I think part of your good communication strategies with your employees can be, making sure they know who to go to.
Right.
Is there, should they go directly to their supervisor? Should they go to a manager? Who they should address those concerns to if they do have individual situations that need to be addressed.
Great. Well, I want to thank you both, Sal Gangemi with Martha Kalina and Caroline Park, a partner with Wigan and Dana. We appreciate your time. And I think we went through a lot of questions that just a lot of our businesses are dealing with right now with a lot of uncertainty, and at least gave them a roadmap of how these issues may fall out. Thanks again. And thank you everyone for joining us. And we'll have another webinar tomorrow for actually our Tech Council presented by Comcast Business, talking about working from home, because we know many people will still be working from home as we move forward. Have a great day, everyone, and we're glad that we at least have this first start of reopening. Thanks.
Yes. Thank you.
Thank you. Thanks. We're done?
Yep. Thanks, Sal.
Great, Garrett. Thank you.